appeal Regency Villas and Resorts.
Yes.
May it please your ladyship, I appear with Mr. Watkins for the third appellant and with Mr. Latimer for the first and second appellants, and Mr. Randall Queen's counsel is for the respondents with Mr. Brown and Miss Longstaff. Lady, the issue in this case is whether you can have an easement to use a golf course, swimming pool or a squash court, and if so, why you can't also have an easement to use a restaurant or a bar or a gym or a seat at Lord's Cricket Ground or to visit the London Zoo. The facilities on this estate at the date of grant are the subject of agreement, which you can find in the core bundle, where the agreed statement of facts and issues lists them at paragraph 14. This is in memory stick page 173.
Well, paragraph 14 lists the ones as the date of grant, and then paragraph 33 lists the
Exactly. So
others.
Your ladyship will recall that the facilities at the date of grant included the outdoor swimming pool, which was later filled in, and there's now one in the basement of the mansion house. There was an 18-hole golf course, 3 squash courts, 2 open-air tennis courts, a restaurant, billiard, snooker room and TV room on the ground floor, a bistro, music area and tavern in the basement, later converted into the basement swimming pool, leisure conditioning suite, sauna and solarium in another part of the basement, Italianate gardens, putting green and croquet lawn, an outdoor jacuzzi and spa pool, an ice roller skating rink, platform tennis court, softball court, riding stables and parkland. The facilities there described were present at the time when the transfer on the 11th of November 1981 was made. The document itself appears to be lost, but the extracts of it that remain are to be found in multiple places. The one I have chosen to use is at page 400 and... lost it. Uh, 79, because there's a blank space opposite it, which is convenient for taking notes if you're following it in paper.
So which page?
Page 47, the memory stick 479.
Thank you.
Entry number 6 on the charges register here records what can be found elsewhere in the bundle. The land is subject to the following rights granted by a transfer of Elam House dated the 11th of November 1981 between Gulf Investments Limited as transferor, Elam House Developments Limited as transferee, and your ladyship sees together with, firstly, the right-of-way for the transferee, its successors in title, its lessees and the occupiers from time to time of the property at all times with or without vehicles for all purpose. In connection...
Well, we don't need to read that
Thank
out,
you. Can I just call to your attention then the next point is another conventional, if I can call it that, set of easements, easements for services. Can I call your ladyship's attention to the last words of the secondly? You'll see that it was contemplated that there might be additions within 80 years of the date hereof. No equivalent is to be found when we look at the thirdly. The thirdly, which is of critical importance to this case, your ladyship has plainly read that. It's a right to use the swimming pool, golf course, squash courts, tennis courts and ground and basement floor of the Broom Park Mansion House, gardens and any other sporting or recreational facilities hereafter called the facilities on the transferor's adjoining estate. My lady, to complete the picture so far as the surviving material enables one to do so, can I ask you also please to look at page 534. We know from Judge Pearl's judgment that the transfer also included covenants, one at least of which is recorded here as a personal covenant from a document that was kept at least for some time by the Land Registry. The transferor hereby covenants with the transferee and its successors entitled to keep properly maintained, repaired, constructed and cleansed the roadways and the facilities. So it isn't a case in which the grant initially contemplated no positive obligation being imposed on the part of the transferor. It is, however, common ground that the personal covenant fell away when the common vendor later transferred the estate. The reference to that is paragraph 28 in Judge Pearl's judgment. That's memory stick page 394. Can I draw your attention to these further factual matters? I'm not sure it'll be necessary to delve into documents to do so. The first is that these were not private facilities dedicated to the use only of those who occupied the villas or the mansion house. From the outset, the contemplation was of using facilities provided to the wider public commercially. This is admitted in the respondent's case, paragraph 6, but it's also a finding of Judge Pearl at paragraph 14, memory stick page 319. Now, this may be a point of some interest when we look at Ellenborough Park. Secondly, the right granted was to use facilities provided by someone else. It was not a right to go on to other land and create one's own and then operate one's own facilities. One can see this most clearly by looking at a passage of the respondent's own case, which we'll have to come back to more than once, at page 310, using the memory stick numbering, paragraph 174.
Sorry, could you repeat the number?
The page number?
Page number.
It starts at page 309.
Thank you.
This is the culmination, or near the culmination, of their argument on Ground 1 and Ellenborough Park. I'll have something to say about that. But the point here to be made is that what is being described is an operation of the timeshare arrangement in which the provision of these facilities by a third party is intrinsic. It's of the essence to the whole operation. The obvious answer, they say at the bottom of page 309, without needing to refer to any of the advertising and promotional materials to produce to assist in selling the same, is for rest and recreation with such of those facilities as were attractive to any given occupier at the time of his or her occupation being readily available to that end. There's then reference to some marketing material, which is in the bundle. I don't think it's necessary to look at it directly, but we can if you like. Regency Villas will be situated within 150 yards of the main clubhouse. As an owner, you will be entitled to use all the facilities currently being enjoyed by the owners of our Broome Park suites. These facilities comprise a championship-length par 72 18-hole golf course and numerous other sports. No costly sports facilities to provide or upkeep, as these are all complete and paid for by our Golf and Country Club. In this naturally beautiful setting, you'll enjoy everything that makes an exciting holiday resort: golf, tennis, swimming, horse riding, etc. So your ladyship sees straight away that a situation in which one is expecting to use facilities for free means that somebody else is going to be providing them and intervening positively, operationally, in order to do so. If you had suggested to the original parties that their bargain might ever be that they could go on and provide facilities for themselves and operate them for themselves, bringing their own water into an empty swimming pool, they would have reacted with astonishment. That is not what was contemplated. The next general point is to emphasise the nature of the rights that were envisaged. I've shown you the material which relates to this. They were of a high quality, not basic facilities. The description refers to a championship golf course, not a patch of untended heath where you can go and hit a ball around and fill in or not fill in whatever holes or divots, I think they're called, you make as you go around. And similarly with the other offerings, for your ladyship's note, the marketing material is at pages 455 to 458. And if you read that, you'll see the same kind of quality is attributed to the other facilities as to the golf course. These are high-class facilities. Now, this is relevant when we look at Ground 2, of course. It's true that you can play golf on a barren heath, and the Court of Appeal said that at paragraph 78. But if you'd suggested to the original parties that this was the bargain reflected by their language, they'd have been astonished to hear the suggestion. Can I then turn to Ground 1? Ground 1 concerns what the law requires when it says that to be recognised as an easement, a right must accommodate the dominant tenement. The critical case is Ellenborough Park, and I'm going to go straight to Ellenborough Park after one remark. The one remark I wish to make is about paragraph 36 and 37 of my case, and I wonder if I could ask your ladyship to turn that up. It's at memory stick page 202. Our initial submission under this heading is the crucial requirement is that the land granted over servient land must enhance the enjoyment of the dominant land itself, and we then identify two distinctions. A right granted over land does not accommodate other land in the legally relevant sense merely because either its exercise is conditional on the ownership of the other land, or a person owning land to which the right is attached would particularly benefit from the enjoyment of that right. Now, my lady, there has been no criticism by the respondents of those suggested distinctions. And this is important because, if nothing else, we suggest that those distinctions must be valid. And yet there is no attempt by the respondents to explain what, apart from the matters I've described in paragraph 36, is present in this case. Turning then to Ellenborough Park, this is in volume 1 of the authorities bundle at tab 5, memory stick page 824. My lady, this case is obviously much cited, and it's the locus classicus for the proposition that it contains a statement of the 4 characteristics of easements. But precisely what it established about the tests by which to assess whether those characteristics are present is sometimes misunderstood, including perhaps in the courts in the present case. Now, I would like to start by going to page 163. The facts do appear from the judgment.
What is the electronic page?
856, my lord.
Thank you.
Towards the foot of this page, one finds that passage which is commonly cited, where there's endorsement of what Dr. Cheshire had said about the 4 characteristics of an easement, and I'm sure I need to read those to the court. Over the page is some discussion of these requirements, and I call to your attention, if I may, the whole of the first paragraph on page 164. I'm content to read it to your ladyship, or leave you to do so as you please.
Leave it to us.
Thank you. So there the Master of Rolls has introduced the issues. He then turns to the terms of the conveyance. The point that is of interest and direct bearing to our case is at memory stick page 858, internal page 165. The top of the page, counting about 8 lines down, the words towards the right-hand side of the page, and also the full enjoyment. Does your ladyship have that? And also the full enjoyment at all times hereafter, in common with the other persons to whom such easements may be granted, of the pleasure ground set out and made, and so on. Then, towards the foot of this page, can I call to your attention also a covenant that was present? A covenant, a restrictive covenant on the part of the vendor to keep as an ornamental pleasure ground the plot of ground hereinbefore referred to, in front of and partly encircled by the said Ellenborough Crescent, and also to keep it open. and the last lines of that paragraph, that the same shall at all times remain as an ornamental garden or pleasure ground. In the next paragraph, the Master of the Rolls describes two different categories of house which formed the dominant tenements. The first category were the houses immediately surrounding the garden square, or crescent, or whatever it was. The second category were some few houses, I think 1 street back, but in no case more than 150 or 200 yards away. And the Master of the Rolls' reasoning then starts at the foot of page 859, although not in every case is it recognised that this is part of his reasoning. But it is. It's more than just a description of fact. Omitting, he says, for the moment, these last mentioned few houses, it's clear from the deed from which we've quoted and from the other, I needn't read it to your ladyship, the points of emphasis start about 5 lines from the foot of the page. An essential characteristic, belonging and, properly speaking, appurtenant. An appurtenance is something which is so obviously part of the land conveyed that it doesn't need separate mention in a conveyance. To all and each of them, in substance, instead of each house being confined to its own small or moderate garden, each was to enjoy in common, but in common exclusively. The idea introduced is the idea of collective or communal exclusivity. Exclusively with the other houses in the crescent, a single large private garden. And this distinction is the first time the Master of the Rolls refers to a factor which is absolutely critical in his distinction of the facts before him from the general case of the free use examples that he gave, which you'll see mentioned in our case and which I'll show you in a moment. But he builds on it, reading on, in our judgment, the substance of the matter is not in this respect affected by the fact that some few houses in the immediate proximity of, but not actually fronting upon the park, were also entitled to share the privilege. This extension of the privilege may no doubt be unusual, and at first sight, at any rate, out of line with the conception of the square and its surrounding houses as a symmetrical unit. It has therefore a bearing upon the question of the connection between the right enjoyed and the premises of the relevant house and owners, and must be discussed under the head of Dr. Cheshire's second condition. But in our judgment, the language of the deed is clearly to the effect that the right of enjoyment of the garden was intended to be annexed to the premises sold rather than given as a privilege personal to the purchaser. The enjoyment was not exclusive to those premises alone. It was to be held in common with the like rights annexed to the other houses in, and in some few cases in close proximity to, the square or crescent. But it was not contemplated that like rights should be otherwise extended so as to belong in any sense to premises not forming part of, or at least closely connected with, the square or their owners. Now, this point, which has now been emphasised twice by the Master of the Rolls, is already clearly influencing the line of his reasoning, and we see it, we're going to see it recur repeatedly. At page 168, the Master of the Rolls at the top of the page refers to that covenant that I showed you in the conveyance that he was construing. He describes it as a complement to the rights of enjoyment of the garden.
What does he mean by that?
I think I can't do better than invite you to read on to the end of that paragraph, where I think he's explaining what he means by that. They should fairly be construed as implying a negative covenant on the vendor's part, does your lordship have that halfway through the paragraph, against any user by them of the park otherwise than as a garden.
Does that apply to the obligation of the vendor to maintain it?
I think he's there referring to the obligation not to use it otherwise than as an ornamental garden. I don't think he's referring to the positive obligation to maintain.
And that's purely personal, is it?
That would have been purely personal, yes. The Master of the Rolls then looks at the interpretation of the grant, and I'd invite the court just to read the next paragraph. I don't think I need read it out loud, but it is important. One has to have it in mind rather than for me to make draw points of emphasis to your attention at this stage. The, so to speak, concluding point emerging at the top of page 169. He says the use of the word full doesn't import some wider, less well understood or less definable privilege. So the Master of the Rolls considers that the grant was not too broad or vague to qualify as an easement, but he's recognising that that is a control in this area which needs to be considered. Towards the foot of the page is the start of the Master of the Rolls' direct consideration of the test of accommodation, or the requirement of accommodation. And your ladyship sees that he, near the start of this paragraph, starts by recording some submissions made by Mr. Cross, that the right of full enjoyment of the park was insufficiently connected with the enjoyment of the property conveyed, in that it did not subserve some use which was to be made of that property, and that such a right accordingly could not exist in law as an easement. In this part of his argument, Mr. Cross was invoking a principle which is in our judgment of unchallengeable authority, expounded in many cases, is what a summary of the next sentence means. But the Master of the Rolls is here agreeing with the principle identified by Mr. Cross. As we'll see, the Master of the Rolls, however, considered that it was not breached on the facts. Or, in other words, that it was satisfied on the facts. He then quotes further from Dr. Cheshire's book. Can I invite you to read? I think it'd be helpful if you could read to about halfway through the next page. This is memory stick page 863, but I won't read it aloud unless you'd like me to. Yes, it's 863, is that what I said? I believe for my purposes I can then scan ahead to page 173, memory stick 866. Can it be said then of the right of full enjoyment of the park in question, which was granted by the conveyance, which was intended to be annexed to the property conveyed, that it accommodated and served that property, the dominant tenement? It's clear that the right did in some degree enhance the value of the property, and this consideration can't be dismissed as wholly irrelevant. It is, of course, a point to be noted, but we agree with Mr. Cross's submission that it's in no way decisive of the problem. It's not sufficient to show that the right increased the value of the property conveyed, unless it is also shown that it was connected with the normal enjoyment of that property. Now, my lady, much use has been made of this expression, this formulation, connected with the normal enjoyment of that property. And in some cases, one finds those words wrenched out of this paragraph and treated as if they adequately encapsulated everything you need to know about the law of accommodation. And as we've already seen, without getting into the meat of the case, that is an unfair way to read the Master of the Rolls' reasoning. This formulation restates the characteristic which we are examining. It doesn't tell you how to test whether or not it's satisfied. It's not a test at all. Now, the Master of the Rolls then goes on to say, it appears something else that I think is sometimes misunderstood. It appears to us that the question whether or not this connection exists is primarily one of fact and depends largely on the nature of the alleged dominant tenement and the nature of the right granted. If I may say so, the Master of the Rolls plainly does not there mean it's a jury question. It's one of those cases where the court has to find the primary facts and then identify what legal consequences flow from them. He's not suggesting that it's a matter of mere discretion left to potentially to be left to a jury to decide what doesn't qualify as a property right. To read what he said in that way, or in any way suggestive of that, or containing that possibility, would be unfair to the Master of the Rolls. He then goes on to consider in detail the interpretation of the agreement in light of the background circumstances. And he concludes, your ladyship sees about 2/3 of the way down the page, the inevitable inference is that the houses which were to be built upon the plots were to constitute a residential estate. He goes on to describe the facts which support him in that view. He describes the way in which it was contemplated that that the park would be used and maintained. And then we come on page 174 to that part of the case which is, in my submission, absolutely critical to the disposal of this appeal, at least to an understanding of Ellenborough Park that will help you to dispose of this appeal. On these facts, Mr. Cross submitted that the requisite connection between the right to use the park and the normal enjoyment of the houses which were built around it or near it had not been established. He likened the position to a right granted to the purchaser of a house to use the zoological gardens free of charge or to attend Lord's cricket ground without payment. Such a right would undoubtedly, he said, increase the value of the property conveyed, but could not run with it at law as an easement because there was no sufficient nexus between the enjoyment of the right and the use of the house. It is probably true, we think, that in neither of Mr. Cross's illustrations would the supposed right constitute an easement, for it would be wholly extraneous to and independent of the use of a house as a house, namely as a place in which the householder and his family live and make their home. Now, pausing there, it's clear that the Master of the Rolls accepted that the examples given by Mr. Cross would not qualify as easements. What follows is the reasoning which, in his view, justifies distinguishing the facts from those two free-use examples. Reading on, we find what are the reasons he uses to achieve that effect. A much closer analogy, he says, as it seems to us, is the case of a man selling the freehold of part of his house and granting to the purchaser, his heirs and assigns, the right pertinent to such part to use the garden in common with the vendor and his assigns. In such a case, the test of connection or accommodation would be amply satisfied, for just as the use of a garden undoubtedly enhances and is connected with the normal enjoyment of the house to which it belongs, so also would the right granted in the case supposed be closely connected with the use and enjoyment of the part of the premises sold. Such, we think, is in substance the position in the present case. The park became a communal garden for the benefit and enjoyment of those whose houses adjoined it or were in its close proximity. Its flowers, beds, lawns and walks were calculated to afford all the amenities. I think I can skip over the next 3 lines. He said, we can see no difference in principle between Ellenborough Park and a garden in the ordinary signification of the word. It is the collective garden of the neighbouring houses to whose use it was dedicated. It's not only if you want to be a record breaker that you need dedication. If you want to rely on Ellenborough Park, you need dedication. Dedicated by the owners of the estate, and as such, amply satisfied in our judgment the requirement of connection with the dominant tenements to which it was appurtenant, The result is not affected by the circumstance that the right to the park is in this case enjoyed by some few houses which are not immediately fronting on the park. So he's alive to the point that because in his analogy situation he regards this garden as appurtenant, it's so obvious that it goes with the house that it passes an appurtenance. He recognises there's a problem when you apply that to the houses a little bit further away. So here is some extra reasoning to deal with that situation. The result is not affected by the circumstance that the right to the park is in this case enjoyed by some few houses which are not immediately fronting on the park. The test for present purposes, no doubt, is that the park should constitute, in a real and intelligible sense, the garden, albeit the communal garden, of the houses to which its enjoyment is annexed, but we think that the test is satisfied as regards these few neighbouring, though not adjacent houses. We think that the extension of the right of enjoyment to these few houses does not negative the presence of the necessary nexus, and your ladyship will note the way that is put. It doesn't negative the nexus. The nexus established by that close physical proximity between the garden on the one hand and the houses on the other, combined with the dedication of the garden to the use of those dominant tenements. My lady, then is reference to that case of Hill and Tupper, which it's common ground between us, that this is a good summary of what was decided in Hill and Tupper. So I invite you to read that paragraph.
Mm-hmm.
So that brings the Master of the Rolls to the end of his consideration of that issue of accommodation, which is at the heart of this case. In the rest of his judgment, he deals with topics which actually don't really arise or only arise indirectly in our case. He deals with whether or not the conclusion he had reached was vitiated by the fact that the right might be regarded as amounting to a jus spatiandi or a right of recreation. He said, no, that doesn't detract from the position, and we don't take issue with that. He also held that the right which had been granted didn't offend the ouster principle, and we don't take issue with the view that the rights which were granted in Ellenborough Park would not have engaged the ouster principle. So the rest of the judgment isn't really dealing with points that are in issue in the present case. But it's interesting just to notice that the Master of the Rolls, when he's dealing with those other issues, comes back to the point of emphasis he has already made about the special facts which justify distinguishing the free use cases. Can I show you first at memory stick page 869? Towards the end of the first main paragraph on this page, where he's dealing with the jus spatiandi, the last 4 lines, he distinguishes a jus spatiandi from what's happened in this case. He says, although easily intelligible as the subject matter of a personal license, is something substantially different from the subject matter of the grant in question, namely, the provision for a limited number of houses in a uniform crescent of one single, large, but private garden. And towards the end of the next paragraph as well, he says, we see nothing repugnant to a man's proprietorship or possession of a piece of land that he should decide to make it and maintain it as an ornamental garden and should grant rights to a limited number of other persons to come into it for the enjoyment of its amenities. Likewise at page 179. About 9 lines down, a sentence beginning, no doubt a garden is a pleasure. Does your ladyship have that? It's at memory stick page 872.
A lovesome thing, God wot. Doesn't actually say that, but never mind.
Here, again, the word appurtenant.
Purest of pleasure.
The word crops up.
Or is it you don't have to do the weeding?
Well, I think of Andrew Marvell about her.
Applying that sort of analysis, we have to look at these timeshare units not as ordinary houses for use as a house, but as a place for relatively short holidays by persons who want to enjoy a holiday, bearing in mind that they have been built in, not quite the middle of, but entirely surrounded by leisure park.
Yes. The critical factor, however, is that in combination, the use of the facilities by the people living in the villas and the mansion house does not exhaust the use of the facilities, because the facilities are open not only to that limited class. It's not a private facility dedicated to their use. It's a public facility to which they have privileged access because of their ownership or occupation of the timeshare villas or units in the mansion house, which are on the same estate. So the short point is that they are partaking in somebody else's commercial undertaking on privileged terms. It is exactly the same as the free use examples. And one sees the same point made towards the foot of page 179, the first 5 lines of the last paragraph on that page. And again emphatically stated at the top of the next page. A private garden, on the other hand, is an attribute of the ordinary enjoyment of the residents to which it is attached, and the right of wandering in it is but one method of enjoying it. So really, there are these repeated emphases recurring throughout the judgment, giving one the clue about what are the facts which distinguish a communal garden from the free use examples. Now, can I turn then to some submissions about this, please? The respondents have not suggested that the free use examples could take effect as easements. So there's no challenge to the Master of the Rolls' acceptance. A right to use the zoo or Lord's cricket ground would not be effective as easements.
Why is that?
Well, the Master of the Rolls gave the reason that they are independent of the use of the associated dwelling house. The way I would put it is that when you go from your house to visit Lords or look at animals in the zoo, your use of the house is not in any way enhanced.
Yes. So it's not a whether that is a comparable situation, basically is going to depend on the facts, isn't it?
It will be influenced by the facts, but the facts, in order to have a legal difference, must be in some distinctive way closer, at least, to the communal garden type situation than the free use examples. And the difficulty in this case is that the respondents haven't attempted to explain. One of the difficulties is they haven't attempted to explain how their facts are distinguishable from the free use examples.
Well, I think that the distinction was suggested to you by my Lord Briggs.
Well, it's certainly true that the agreements were entered into in contemplation of of their being made available to the occupiers of the villas and the parts of the mansion houses, all these facilities. But that wouldn't distinguish the position from the free use example. Suppose a new Lord's cricket ground were to be instituted because the old one burnt down. And suppose it were decided that in order to help finance that project, some nearby land should be developed for houses and sold off, and that in order to increase the purchase price, an easement should be granted in favour of those houses to attend Lord's cricket ground. Still, in that situation, what is being granted is not a right of benefit by reason. It's not of benefit to any use you make of the land itself.
Well, that all depends, doesn't it? I mean, the question is, are we talking about a general rule of law here, or about a summary of what is usually the relevant factual situation? I can imagine a factual situation in which it might well be an integral part of the enjoyment of a property. Maybe you should be able to visit Lords for free.
Well, certainly, enjoyment in the sense of pleasure can be derived from visiting lords.
Yes, but it's more than that. Sometimes you can have a dominant tenant whose creation is so intimately associated with the enjoyment of a particular facility that a different consequence arises.
Well, my lord, this is why this is perhaps the point of principal difference between the parties, because we don't accept that. Once you go down that...
Okay, it's legally impossible to contrive a state of facts in which a dominant tenement may depend for its enjoyableness to visit Lloyd's.
No, you can certainly envisage it. To take the example of an empty field, which as an empty field has no use other than agricultural, because it has no easement to take supplies from water, electricity undertakers, and so on. In that situation, the enjoyment of the property will be much enhanced by the provision of those facilities. Of course it will. But that's because the facilities once provided will enable a new set of uses to be made of the land. It will be your use of the land which is enhanced by the provision of those facilities. What is not the same at all as a situation where the facility which is granted is merely to go, for example, to go and park your car in the nearby supermarket. That's not of use to the land itself. It's a nice thing to have, and if it is attached to the land, then people will pay more for it. But that's not what this area of the law is about. This area of the law is intended to distinguish between personal rights and rights which should have that privilege of binding third parties because they're property rights. We'll see this developed in other cases, but as a shorthand answer to my Lord's point, that is it. The quest is on to find some rational basis for giving to some rights a privilege which is not enjoyed by others.
You made quite a lot, and I understand why, of the particular facts of Ellenborough Park and the fact that it's sort of set like a private garden, and this, you say, is very different from that. And at the other end of the spectrum, we have a case like Hill and Tupper, where you have a sort of right to, which is beneficial to the land, but isn't said to be connected with it. Again, it's not very like this case. I mean, is there no case in between where you have a use which is clearly connected with the particular enjoyment of a timeshare property?
Yes, I'm going to give you examples. Yeah. I'm going to choose my examples selectively. I'm only going to show you a handful. I'm not going to go through the whole bundle, but I think it would be a sufficient sample because I'm going to be using cases that are agreed apply principle correctly. Mm. Anyway, the court has seen the basis on which the Master of the Rolls distinguished the free use examples. And I noticed that the respondents treat that part of the Master of the Rolls' reasoning where he explains the factual situation and its special features as a mere summary of the factual position. If you go to their case at paragraph 158, this is in Memory Stick 299, towards the foot of the page. The judgment is characterised in this way. The Court of Appeal considered that whilst enhancing the value of the dominant tenant cannot be dismissed as wholly irrelevant, and is of course a point to be noted, it is in no way decisive of the problem. It's not sufficient to show that the right increased the value of the property conveyed, unless it is also shown that it was connected with the normal enjoyment of that property. However, having described in summary the role which the park fulfilled in relation to the neighbouring houses and their occupants, 174 last 11 lines, and so on, that, I suggest, is not a fair reading of the Master of the Rolls' judgment. In those 11 lines, the Master of the Rolls is not merely summarising something, that is part of his reasoning, which explains why he can distinguish the free use examples. Now, I am going respectfully to question whether the Master of the Rolls' reasons were adequate. I will question that. But I can quite see that the wind may be against me on that. But if the wind is against me on that, it doesn't really help the respondents because they are not able to point to any of those features, those special features which would justify treating these leisure facilities as appurtenances to their properties.
I can see that that might be so if the property in question was just a house, a dwelling house. But where the whole purpose of the construction of the house is that it's a holiday base, if you like, for people who are not going out to work but taking leisure, it does seem to me to beg the question whether an over-fine analysis of the particular factors which impress the Master of the Rolls in Ellenborough Park is going to be conclusive.
Going to be difficult then to find the dividing line, because it's going to be difficult to formulate the test in a way which doesn't entitle one to attach an easement to treat as an easement a right to use a restaurant, for example, or a bar, or a sauna, or other facilities, which one would think were obviously outside the scope of what could be made the subject of an easement. The provision of facilities is something not within the scope of what the law of property can accommodate as a right in rem. It's going to become very difficult to draw a clear and coherent line. We in fact made this point in our case, paragraphs 41 to 42. Memory stick 203. I was going to come back to this after looking at Moody and Chapman and Edwards. We've said what distinguishes the two cases is that in the first, the potential use of the servient tenement was of specific benefit to the potential use of the dominant tenement itself, whereas in the second it was not. We have submitted that no other line can be drawn coherently between rights which accommodate the dominant tenement on the one hand, and on the other hand rights which are merely contractual, even though they may possess particular value to someone who owned the dominant tenement. And that hasn't been answered in the case against us. It's not suggested that there is some other test which can draw a coherent distinction between those two classes of right. Can I add a reference quickly to an authority which my learned friend asked to be added to the rather long bundles on Friday, because I wondered whether it might say something different from what I have been saying to your ladyship. This is now, I hope you have this yet further volume 6 of the authorities. I don't think it will be in memory stick form, because always I don't think good adequately enough.
I suspect that it will be in memory stick form.
Because we had a new bundle.
Yeah.
We got an additional corrected bundle. Give us a page number and we can see.
Well,
Yes, I don't think I have got this. It certainly arrived in my room.
it's supplemental page number
Well, I-
103. So
I recognise the bundle. I don't know whether you have a spare.
I
have one here.
Oh, it's all right. We've got one here.
sign it.
Yes, I've got it as a separate memory stick.
I myself haven't had any electronic copy of it, and I didn't know one had been made. But
What's the name of the case?
it's Ducart, my lord.
Yes.
It's the last tab now, 116.
Yeah.
Fortunately, the index doesn't. It's not an electronic index.
Tab 116. It's 103 of the supplementary bundle.
Yeah.
This concerned rights over foreshore reservations in the Supreme Court of Canada. Ellenborough Park was cited, and we see, starting at page 617 internally, supplemental page number 111, how it was applied. Towards the page, the last two paragraphs. This, of course, only carries us to the question as to whether any grant of easement has here been made by and between the predecessors in title. In the Ellenborough case, the grant was clear, and the question was whether such a grant took on in law the character of an easement. The question before us is whether, accepting that the law of easement is settled on the issue of the status in law for just speciandi, such a grant has here been made. In anticipation of this root question, the relevant recitals and operative covenants have already been set out. There is, of course, no express covenant by the grantor to make available and to continue to make available the foreshore reserves to the grantee in common with all others in the Crescent Beach development. Can such a covenant to dedicate to the owners of lots in the Crescent Beach development these foreshore reserves and to the use in common thereof be implied. And he went on to answer that question affirmatively. I can call your attention, if I may, to the foot of page 11, supplemental page 112, where he's quoting from the trial judge. The word reserve itself implies that the parcel so designated will be reserved for the use of the neighbouring owners. So again, the concept being applied here is the one I indicated, and the Master of the Rolls in Ellenborough Park emphasised its dedication. That's what supplies the necessary nexus in this type of case. Now, may I illustrate the correct application of the accommodation principle by looking at, I think, I'm only going to show you, I think, on this point.
Just before we leave this case, was it an exclusive dedication?
That seems to have been the analysis, yes, that if you looked at the dominant tenements which were the beneficiaries of this grant, the land was reserved exclusively for their use. That's how
But was it for their exclusive use?
That's how I understand the judgment to have proceeded, yes. That's how I understand that part of that's what I understand that part of the reasoning to be directed to. That's the justification used for treating the foreshore as affected by this right of recreation as a property right, going beyond a mere licence. And one can quarrel with whether that view should have been taken, but that was the justification. Milady, can I now turn to Hill and Tupper, which its common ground was summarised by accurately by the Master of the Rolls in that passage I showed you, and I note that the respondents don't challenge Hill and Tupper. It's at volume 3 in the authorities bundle, at memory stick 1365.
Can you give me the tab number as well, please?
My lord, it's 38.
Thank you.
And really, the only reason I show you this separately from the point that the Master of the Rolls made about it in Ellenborough Park is that it contains a useful set of dicta as to the underlying, one might call it the legal policy in this field. If I could call your attention to memory stick page 1366, as is about two-thirds of the way down the page, the Baron Martin interrupted argument to say the plaintiff is setting up a right of a perfectly novel character, and there's a reference to Keppel and Bailey. And the Chief Baron at the next page interrupts the argument again about 6 lines down. If the plaintiff's contention were correct, the number and variety of rights which might be thus created over land for a particular purpose would be infinite. The whole question depends on whether a new species of property can be created or whether the alleged right merely exists in covenant. And the Chief Baron, in giving his judgment just over halfway down the page, says, after the very full argument which has taken place, I don't think it's necessary to assign any other reason for our decision than that the case of Ackroyd and Smith expressly decided that it's not competent to create rights unconnected with the use and enjoyment of land and annex them to it so as to constitute a property in the grantee. And towards the foot of that paragraph, he says, a grantor may bind himself by covenant to allow any right he pleases over his property, but he cannot annex to it a new incident so as to enable the grantee to sue in his own name for an infringement of such a limited right as that now claimed. And Baron Martin gave a short judgment, which I'd invite you to read as well. So your ladyship remembers that the facts in Hill and Tupper were that the lease related to some facilities for boating, a boathouse and mooring facilities on the land, and an exclusive right to sail over the adjoining body of water for recreation. And the view of the court was that that could not qualify as an easement because it got things the wrong way round. Instead of the right granted benefiting the supposedly dominant land, it was the other way round. If anything, the dominant land was a mere accessory to the right granted. I suggest one sees strong overtones of that in the present case. Likewise here, occupation of these villas and of the flats in the mansion house is of no intrinsic utility beyond their ability to bring you nearer to the facilities for recreation and sport elsewhere on the estate. Now, the respondents say at paragraph 157, memory stick 299, that Hill and Tupper is remote on the facts. That's all they say. They don't tell us what about the facts is legally relevant, which distinguishes Hill and Tupper from their case. And I suggest there are no legally relevant distinctions. As in Hill and Tupper, the relationship between the villas and the facilities is the reverse of that relationship of subservience which is required. For my next case, I need to go back to volume 1, please, tab 7, memory stick page 927, where we find Moody and Steggles.
Sorry, could you give me the number again?
927, my lord.
Thank you.
This is the pub case, where the facts were that the Moody's owned a pub which you couldn't see from the highway because it was blocked by a building. But they had acquired, I think by long use, an easement to fix a sign next to the, on the adjoining house, which told anyone interested that there was a pub nearby. So it was a pub sign on an adjoining house, which advertised the location of the pub. And the reasoning of Mr. Justice Fry, which is of relevance here, is at page 266 internally, memory stick 932. It said that the easement in question relates not to the tenement, but to the business of the occupant of the tenement, and that therefore I cannot tie the easement to the house. It appears to me that that argument is of too refined a nature to prevail, and for this reason, that the house can only be used by an occupant, and that the occupant only uses the house for the business which he pursues, and therefore in some manner, direct or indirect, an easement is more or less connected with the mode in which the occupant of the house uses it. To illustrate this by the cases which have been cited, the easement which was upheld in Wood and Hewitt was to have a hatch in another man's soil. The hatch was only useful to the tenement, so long as the plaintiff occupied it as a miller. In that sense, the easement was connected with the business of the occupant. So in Lancaster and Eve, the easement was to have a pile fixed in the waterway of the Thames, which was useful so long only as the occupant of the plaintiff's business used them for the purposes of a wharf. Similarly in Hoare, which is still more like the present case, the easement was to have a signboard supported by a pole fixed into the common, an easement which could be useful only so long as the occupant used the house for some purpose which rendered an invitation to the public desirable. Only so long as the occupant used the house for some purpose which rendered an invitation to the public desirable. If we reflect on what that means, take the example of an advertising company which moved in after the Moody's pub had closed down. It's no longer a pub, it's premises used by an advertising business. They still have the easement to put up a sign. But what can they put on the sign? They can certainly put up the name of their business, and if they want, a sign saying turn right to whatever it is, Saatchi & Saatchi. But can they put up a sign advertising Coca-Cola? No. That is the critical distinction which Mr. Justice Fry plainly recognised. And that is notwithstanding that the business of the occupant is advertising. The sign for Coca-Cola would be of use to the business carried on from the premises, but not of use to the business carried on the premises. That is the legally relevant distinction, which Mr. Justice Fry correctly recognised and which is not challenged by these respondents.
How does that tie in with Hill and Tupper? Because there the plaintiff was using the premises on the canal side for his boat business, wasn't he?
Yes, he was, but the point in Hill and Tupper was a slightly different one. It was that it couldn't be said that the right of boating facilitated the use of the boathouse.
Well, it's not much use having a boathouse if you haven't got somewhere to put your boats.
But one sees how strictly the test was applied. Yeah. How rigorous the law is on this point for reasons of good legal policy.
I just find what the distinction is. I mean,
yes.
Because Hill and Tupper sort of favours you, but I'm not quite sure how you distinguish it from this sort of situation.
Well, I'm not sure that there is necessarily a distinction between Hill and Tupper and Moody and Steggles. I'm not sure they are applying any different principle. I suggest that if, when one thinks about it, one discovers that there is a difference on the facts, it's not because Mr. Justice Fry meant to apply any different principle.
Speaking for myself, I wouldn't necessarily assume that Hill and Tupper is right, because it's at least specifically a boathouse with a right to say to the person which is the use of that boathouse.
Yes.
It's a very old decision to make.
My Lord, I've set out the reasoning. I say that it is consistent with principle. It hasn't been criticised by these respondents, and it was accepted in Ellenborough Park as an accurate statement of principle. But I am fortified. In a way, I can afford to lose on that point, because I am fortified by Moody and Steggles, which is another case which isn't criticised. It seems to be consistent with what the respondents accept to be a correct statement of principle. And I'm further fortified by Clapman and Edwards, which is the next case I need to show you, which is in Volume 1 at tab 3. This is the other advertising case, which twins quite well with the one we've just looked at. It was a case where
I've got no difficulty with the advertising cases, because in one contrast between those two cases, in one case, the recording was integral to the value of the land, the use of the land. In other words, purely incidental. My problem with Hill and Tupper is that the use of the water for which the purpose the boathouse existed wasn't purely incidental.
Well, my Lord, at the level of at a broad level of analysis, I think I would be with your Lordship to this extent, that when there is a degree of circularity in asking what is the normal use of premises without asking what rights are associated with those premises. You can't ask the first question without first understanding what rights go with it. That is one of the problems of the test the respondents rely on. This idea that there is such a thing as a normal use of property as an abstract notion divorced from a reflection of what rights actually belong with it.
Yes, but if the property is a boathouse on a canal.
But if you're asking, when one descends to the question of how does that proposition apply in the context of Hill and Tupper, I would repeat the analysis that the Master of the Rolls used in Ellenborough Park, which I suggest, which is common ground between us anyway, is the right analysis. He recognised that the court in Hill and Tupper saw that the relationship of subservience was not present. I mean, these things are called dominant tenements and servient tenements for a reason. The clue is in the label. And you can't, a situation in which on a true analysis, what's put forward as the servient tenement is actually dominant, will not engage the doctrine of easements. That's the point being made. In this case, the tail wagging the dog in that situation. Clapman and Edwards at tab 3, this is memory stick page 804. My lady, may I just ask you to read the head note rather than to, I mean, they're very simple facts.
(864), did you say?
My lady, yes. 804.
804.
Yes, we've been to 864 before.
Thank you. Can I then just remind you of what the words were which were being construed? These are on memory stick 807, just below letter D. Also, with the right to use the flank walls of the adjoining premises marked A and B on the plan hereto annexed for advertising purposes. Now, it's suited, in this case, it suited the landlady to argue that an easement had been created because she sought to restrict what could be shown on the flank walls. I think she was trying to monetize the arrangement. At page 512, Mr. Justice Bennett's reasoning deals with this. He quotes the words that I've just shown you next to letter C. Memory stick
electronic page?
Memory stick 809, my lord. I'm sorry, I'm muddling up
Right.
internal and memory stick numbers. The words are, to use the flank walls of the adjoining premises on the plan hereto annexed for advertising purposes, I can see no reason why I should imply into the lease words, restricting the right of the defendant to advertising only his own business or something connected with his own business upon the flank walls in question. Once that interpretation or construction is put upon the first clause of the lease, it becomes impossible to hold as a matter of law that which Mr. Miller granted to the defendant was an easement, because that cannot be an easement which is not related to or granted in respect of the dominant tenement, the user of which is not limited by the requirements of the dominant tenement. If it were to enable the grantee, as I hold it does, to advertise anything he chooses upon the flank walls in question, there is no connection between the dominant tenement and the servient tenement in the flank walls in respect to such users. So he's making the same point as I made by reference to the example of an advertiser taking over the pub in Moody's case. And setting Clapman alongside Moody, we get a helpful insight which is actually acknowledged and expressed quite helpfully by the respondents themselves. Can I show you in their case? At memory stick page 308. In paragraph 171. Here there is their analysis of Clapman and Edwards. They say it is clear from the tenor of Mr. Justice Bennett's judgment that placing advertising limited to promoting the petrol station business carried on upon the putative dominant tenement would have been acceptable as an easement. With that sentence, I wholeheartedly concur. That is right. But it gives us a crucial insight. Because both these cases are dealing with businesses, it happens that as a matter of ordinary English, we have available an expression which captures the point. It's the difference between a business carried on premises and a business carried on from premises. It's fortuitous that in ordinary English we have that expression, but the concept, readily understood in a business setting, also translates to other uses. So although it sounds unnatural and one wouldn't dream of using the expression in ordinary English, the concept of living from premises may be relevant here. I suggest that the Master of the Rolls was right to reject the free use examples in Edinburgh Park because they don't enhance the residential use carried on upon the premises. The same is true of the villa in examples here. The right to use the recreational facilities does not enhance the residential use carried on the premises. Even if one could, swallow one's pride and use a solecism, such as it could be said to enhance the residential use carried on from the premises. It would be an extraordinary use of English, but I hope your ladyship has the point. The concept is the same. The next authority is Close Farming and Easton, and my lady, this is in volume 1, tab 11. The memory stick number is 1018. It's the case about viniculture. And could I ask your ladyship to read paragraphs 13 to 14. Then move to 23, where the issues are identified. The first of which is whether the easement for vineyard was a valid easement. I think one can then go to paragraph 30. I think I can take it up from about halfway down, paragraph 31, actually. The nexus must exist in a real and intelligible sense. He's describing the view of the judge below. Mr. Justice Bryson recognised that facilitation of the business or commercial use in which the dominant land is involved may in limited circumstances be nonetheless sufficient to create the requisite nexus, provided the criteria for an easement is satisfied. He concluded that in reality the 14th restriction did not accommodate Lot 86 as a piece of land. This was because he concluded there was no evidence supporting any accommodation, advantage or enhancement of Lot 86. Thus, Lot 86 could be a convenient incident to action under the 14th restriction, but that is not enough. Convenience is not enough. And then in paragraph 32, we see recorded what is practically the argument of the respondents in our case. It was submitted that the 14th restriction rendered Lot 86 a more convenient place in which Close Farming, as dominant owner, conducts its business of farm management, and that this established a sufficient accommodation. It was submitted that the requirement that the easement sufficiently accommodate the dominant tenement is in effect a requirement that the easement make the property better and more convenient. This may be achieved, it was argued, as in this case, merely by benefiting some trade carried out on the property. Then in paragraph 34 are the submissions in answer, which are important because the court expresses agreement with them. The respondent emphasised the appellant hadn't sought to challenge the long-established principle that the dominant tenement as land must nonetheless be benefited by the easement. The respondents acknowledged that a right benefiting a trade carried out on the dominant tenement may in appropriate circumstances be a valid easement, but this is provided that the conduct of the trade is a necessary incident to the normal enjoyment of the land, not merely an independent business exercise. The respondents submit that in accordance with the authority dating back to Hill and Tupper, Lot 86 as the supposed dominant tenement was not relevantly benefited by the rights conferred. This was because it was merely a convenience and a matter of efficiency that Lot 86 be used for the purposes of farm management. Secondly, it was put that there was no feature of Lot 86 that rendered it the natural or only place from which to carry out harvesting and associated works. Highlighted was that in the agreed statement of facts there was no evidence which indicated that farm management, as distinct from storage, was actually carried out on that lot. The supposed connection was thus not a real one. I would agree. The reasoning returns to this topic at paragraph 40. It's clear that the rights in toto, when given effect, are not merely novel. They breach what is fundamental to constituting an easement at law in the two respects identified. The rights perpetually granted are extensive, leaving little by way of residue. That's to do with ouster, which I don't particularly rely on this case for ouster. I'll deal separately with that. Then he deals with novelty. He says novelty alone is insufficient to bar the recognition of the creation of an easement. I don't suggest otherwise, of course. Nevertheless, at the end of that paragraph, he says it's still necessary that the character of the new right be capable of meeting and satisfying the conditions for easements as propounded in Ellenborough Park. In relation to the second condition, the argument, I'm now at 43, the arguments put by the appellant do not show that Mr. Justice Bryson made any error in finding there was not a sufficient accommodation. The appellant was unable to establish that the connection between the land and the industry carried out on the land was more than just a mere convenience as required to establish the requisite connection, and so on. And then in paragraph 44, there's further reasoning which I rely on. The suggestion cannot be sustained that accommodation of the dominant tenement should be found in the supposed commercial necessity on the part of the owners of close farming to ensure that the rights that they purportedly hold have economic value. Even if correct, pure commercial interests of themselves, they're not necessarily incompatible with an easement and not sufficient to justify and may even militate against the creation of such a right in rem. For such a right, if allowed as an easement, would endure in perpetuity, even if the right had long ceased to be exercised. Considering the extensive character of the rights conferred under the 14th restriction, finding such a perpetual right in rem as distinct from a mere contractual right would clearly run counter to the commercial interests of the servient owners. This is because while the dominant owner has numerous entitlements, the servient owners have no entitlement to compel close farming, and so on. So drawing those strands together, I suggest that the court here has recognised and applied correctly the reasoning in Ellenborough Park that I have sought to show your ladyship. It recognises the absence of any benefit conferred by the right to use the servient land on the use of the dominant land. It recognises the independence of the use of the servient land as a feature which is incompatible with easements. Now, I need to make this point, that the respondents have not said that close farming is wrongly decided or that it wrongly states the principle. In fact, they rely on a passage in Gale on Easements where close farming, including the extracts I've shown you, is put forward as an accurate statement of the law. Can I show you? This is in their paragraph 32. It's memory stick 251. Paragraph 32, at the end of the quotation, it said, for further cases considering this principle, what they call the sufficient connection test, see an extract from Gale. That's in the authorities volumes at tab 71. If you'd like to verify that, so you need to go, I think, to tab 4. Bundle 4. Bundle 4, forgive me. Tab 71. Paragraph 124 starts at memory stick 1804. and I don't invite you to do more than just turn over the pages to see on memory stick 1806 an extract from close farming. So close farming is adopted by these respondents as correct. And yet, can I remind you of what we said in our case, paragraph 86? This is memory stick page 215. We said that the New South Wales Court of Appeal's approach to the requirement of accommodation supports the appellant's analysis. No answer. It appears to be accepted. I mean, it clearly isn't, but it is. Well, the problem is we don't know why not. We haven't been told. What is the explanation?
What was actually going on in lot 86 in close farming? I couldn't quite work that out.
Yes, well, I think that the shortest answer is to go back to the factual description, which is at memory stick 1021. And I think it's probably paragraphs 8 through to 10, maybe 8 through to 9 will be sufficient. Developer retained lot 86 with close farming as the proprietor. The only improvements that have been made have been the construction of a machinery shed, a chemical shed and a brick farm office block at all relevant time. It's a bit like Hill and Tupper.
Well, except that he was he running the farm from there, or was he just storing farm machinery? Anyway,
I'm not...
I think...
I think it may just have been storage. The last sentence of paragraph 8 refers to storage.
I think paragraph 9 says the system enables small individual yet adjoining farms to present a contiguous area for agricultural operation and production.
Yes.
No.
I think it was rather more than storage, wasn't it?
I mean, my understanding is that they were farming the other land. It's for viniculture. Whether that's accurately called farming or not, I don't know. My lady, then I need to show your ladyship that case of Moncrief. I do so because although it wasn't a case about accommodation, unfortunately, it is the case of highest authority in recent years. And it relates mainly to ouster, which is ground 3. But it does also have some dicta, which I think it's right you should see, even though the issue wasn't directly up for consideration. Moncrief is in volume 1 of the authorities at tab 6, memory stick page 881. May I go straight to what Lord Hope said, memory stick 890 at paragraph 26. It's the parking case, your ladyship will remember it. Proposition for which the pursuers contend that a right of parking may be constituted as a right ancillary to an undoubted right of vehicular access is easier to accommodate within established principles. The essence of a servitude is that it exists for the reasonable and comfortable enjoyment of the dominant tenement. Whether it originates in writing by means of an express grant or is to be inferred from other provisions not expressly creating a servitude, practical considerations may indicate that it will carry with it other rights, which, although they would not qualify on their own as servitudes, are necessary if the dominant proprietor is to make reasonable and comfortable use of the property in favour of which it was granted. This is the principle to which the defenders have given effect by the acknowledgement of the right to turn and to load and unload vehicles on the servient tenant. That is, I respectfully say, Lord Hope correctly identifying what he calls the essence of an easement. This is the essence, because this is what marks particular rights out as deserving the qualities of being treated as rights in rem. One shouldn't be surprised that it's a strict test. There should be nothing surprising about it at all. Can I then go to paragraph 47, where Lord Scott's speech, Lord Scott, of course, is focused on the ouster principle, but I ought to show you what he said about accommodation in paragraph 47. This is Memory Stick 896. I can see no reason in principle, subject to a few qualifications, why any right of limited use of the land of a neighbour that is of its nature of benefit to the dominant land and its owners from time to time should not be capable of being created as a servitudal right in rem, pertinent to the dominant land. He then goes on to talk about the ouster principle, which is not relevant to ground one, but I might as well, I apprehend it will be convenient to your ladyship if I sweep up, rather than having to come back later. Shall I deal with ouster now as well? I mean, he moves on to deal with ouster, saying an essential qualification of the above proposition, which you would derive, is that the reasonable use by the owner of the dominant land mustn't be inconsistent with the beneficial ownership of the servient land by the servient owner. That's 47. I think I can then go to paragraph 57, where Lord Scott discusses right and macadam. I just wanted to pick up a point next to letter G. This is Memory Stick 902, my lady. It says, the servient land, in relation to a servitude or easement, is surely the land over which the servitude or easement is enjoyed, not the totality of the surrounding land of which the servient owner happens to be the owner. If there's an easement of way over a 100-yard roadway on a 1,000-yard estate, or an easement to use for storage a small shed on the estate, access to which is gained via the 100-yard roadway, it would be fairly meaningless in relation to either easement to speak of the whole estate as the servient land. I mention that because of, I think, one of the submissions made on the interpretation of the grant under one of the respondents' grounds of cross-appeal. I think one can then go to paragraph 59, where Lord Scott brings together his reasoning in relation to ouster. He rejects the broad test formulated in London and Blenheim estates, a test, he says, that would reject the claim to an easement if its exercise would leave the servient owner with no reasonable use to which he could put the servient land. I might invite your ladyship just to read that, if I may, that paragraph. I'm going to call attention to the last sentence of it over the page. So the test on ouster that Lord Scott favours is, in the last sentence, I'd reject the test that asks whether the servient owner is left with any reasonable use of his land, and substitute for it a test which asks whether the servient owner retains possession and, subject to the reasonable exercise of the right in question, control of the servient land. And the submission I make about that, I know it's out of order, it's on ground 3, but it seems convenient to make it now, is that where Lord Scott uses the expression subject to the reasonable exercise of the right in question, he's not inviting a sort of circular test whereby whatever control of the servient land is needed for the ordinary use of the right, the corollary will be that the interference is acceptable. That wouldn't be a test at all. He's making the point that there comes a point where the effective exercise of the right entails the dominant owner taking over such a degree of control of the servient land as to be incompatible with regarding the servient owner as having any meaningful control left over it. That's my submission on that part of the paragraph. But can I then return to the flow, back to ground one and accommodation? Can we then move to paragraph 75? This is memory stick page 908. Where we find Lord Roger expressing the requirement of accommodation in the first two sentences, looking at the question as a matter of principle like Lord Scott. I see no reason why a servitude of parking should not be recognised in Scots law. Of course, like any other servitude, it would have to benefit the dominant proprietor in his enjoyment of the dominant tenement. And he gives the example from Mycenius, if that's the correct pronunciation, which he contrasts with. I've obviously erred, but sorry. But in the last sentence, he contrasts it with, well, your ladyship sees the contrasts being made.
Well, Lord Roger can be relied upon to find a Roman law example.
Yes, exactly.
If there is one.
If there is one. And then at page 134, we're now in Lord Newburger's judgment. Sorry, this is memory stick page 923. Next to letter E, just to satisfy you that the real thrust of Moncrief is about ouster. Does your ladyship see next to letter E? The fundamental point relied on to justify the contention that a right to park cannot, as a matter of law, be a servitude, is that it would involve the partial or total exclusion of the serving proprietor. So that was what Moncrief was about. It's unfortunate because it comes tantalisingly close to grappling with the area that is now detaining us, but that wasn't the Schwerpunkt of the reasoning of any of the judges. At page 925, using the memory stick, internal page 2664, paragraph 143, Lord Newburger expresses his attraction to the views of Lord Scott, but he draws back from endorsing them, and your ladyship sees at the foot of paragraph 143, he says, unless it's necessary to decide the point to dispose of this appeal, I consider it would be dangerous to try and identify a degree of ouster is required to disqualify a right from constituting a servitude or easement, given the very limited argument the lordships have received on the topic. And he expresses some concern about possible knock-on effects if Lord Scott's approach were to be adopted. In particular, he's concerned about the risk of resurrecting the spectre of an occupational licence and the risk that that might re-enter the law, having been exposed as a heresy, some time ago. So that's what Moncrief says about it, and I showed that to your ladyship under ground one, really for completeness, so you can see what the highest court has said that touches on the subject, even though it's not in relation to a point then in issue. The next case I must show you is, and I think it's the last one, is Polo Woods. This also is in volume 1 at tab 8. Memory stick 935.
935.
Yes, my lady.
Thank you.
I think that probably the most efficient way through this case is to invite your ladyship to read the headnote, if you wouldn't mind, at least down to the first 6 lines of memory stick page 936. The relationship has had a chance to consider. I can see the point actually established by this case is the one in those lines that I referred to. There's no test of real or appreciable benefit to the dominant tenement which has to be passed before a right claim could be said to accommodate it or to establish the necessary connection or nexus. Can I then ask you to turn to memory stick page 938 for paragraph 6 and 7, where the judge, Mr. Justice Warren, records the adjudicator's factual conclusions. Because as I've stated, I'm satisfied that for over 20 years, an indefinite number of ponies, never more than 10 and frequently less than 5, entered onto the triangle between the hours of 5:30 and 6 between March and October as part of their daily routine, and that in the course of so doing they occasionally grazed. Taken on its own, the triangle would not be capable of providing enough stocking material or for even one horse over the period in question. So the adjudicator was making the point that this wasn't much use to the dominant owner. Not much use. And the judge records in the next paragraph a similar point. It's not, as found by the adjudicator, it's not on any footing necessary for the farm to be able to allow ponies to graze on this land. The value of the grass on the triangle is negligible. As I've said above, the grass can only provide grazing for less than one horse over the period. So he's emphasising the adjudicator's findings, which are to much the same effect, that this right was of so little value that the farm could manage easily without it. And can I tell your ladyship in a nutshell what this case establishes? It is that that kind of consideration is irrelevant. The law of easements isn't concerned with how much benefit the dominant land gets from the servient land. It wouldn't have made a difference if 30 horses had been adequately fed from the land. There's no threshold about the quantity of benefit that will suffice. And that is the point decided by this case. Nothing else actually is decided by it. But of course it contains reasons. Can I then show you at paragraph 36 Mr. Justice Warren's discussion of the concept of normal enjoyment, which he comes to after looking at Ellenborough Park. And the first thing he does is to note that it may create difficulties in some cases. I'm sorry, did I give the reference? It's memory stick 945, paragraph 36. And unhappily for us, the precise content of that requirement was not an issue before him. Otherwise, we might have learned more about it. He goes on, though. He says, in the present case, the enjoyment of the farm as a farm, including its use for the rearing of ponies, must surely constitute normal enjoyment as much as growing crops or keeping a dairy herd. Further, the words benefit or beneficial must be taken with a great deal of caution. The words do not stand in isolation in these quoted sentences or in other similar contexts where one finds them. Well, this perhaps goes to my Lord Sumption's point. They're used to distinguish that which is of benefit or utility to the land or the owner of land as such from that which is a benefit or utility to an individual personally, albeit he is an owner of land. The benefit is simply assumed to exist because it is nearly always obvious that there is a benefit to someone, the issue being whether it is a benefit to the land. That is our point.
I think we may have got the point, actually,
Yeah.
Mr. Morshead.
Well, sorry. The reason I emphasise it is because I think this case is prayed in aid against me, and I'm anticipating that. Well, I'll try to go more quickly, Milene. I'm sorry. Then in paragraph 30, I'm not sure I need to show. Paragraph 39, if you'll note, is really the hook on which the conclusion to the case that I described to your ladyship earlier hangs. The question was whether reasonably necessary carried a quantitative element to it. Yes, Milady, unless I'm asked to by my learned friend, I don't think actually I need to show you any other part of that judgment at this stage. Milady, the final document I need to show you is the Law Commission's consultation paper, which is in volume 5 at tab 85. Oh, sorry, yes. My learned friend reminds me that the copy in volume 5 was slightly incomplete. So volume 6 is a better place to go, where there's another tab 85. But both parties have relied on this, so it's right I should show you at least the relevant parts of it. At tab 85, internal numbering, page 15, supplemental page number 65, if you have a memory stick. Paragraph 3.1 sets out by reference to Edinburgh Park those very familiar 4 requirements. In paragraph 3.6, the Commission says we don't intend to analyse whether the rule against easements in gross is soundly based on authority and is therefore good law in the narrow sense. We consider it unlikely, in view of the prevalent authority, that the rule would be successfully challenged in the course of contested litigation. The question we intend to ask consultees is whether there are good policy reasons for retaining it, or whether there would be advantages in allowing easements in gross to be granted, meaning, of course, a right that could pass without there being ownership of land, and therefore without this requirement of accommodation. At paragraph 3.11, the Law Commission's starting view was this: our starting point is the general proposition that we should be wary of creating new interests which potentially bind the land in perpetuity. Unless there are very good reasons for allowing such interests to be enforceable by and against successors entitled to the original parties, we should resist taking that course. If the law were to allow easements in gross, this would confer proprietary status on arrangements which currently can take effect as no more than contractual licenses. Then in paragraph 3.25...
What was the date of this document, please?
I'm told 2008.
So who were the law commissioners responsible?
I'll have to look that up.
Well, Sir
Oh, they are listed.
There,
Page
Sir.
53. Mr. Justice Etherton, Mr. Bridge, Mr. Herzl, Professor Horder, and Mr. Parker QC.
I think I would detect Mr. Bridges' hand in this.
Which paragraph are we now going to?
325. The Law Commission says in Part 8, we review the requirement relevant in relation to the law of covenants that a covenant must touch and concern the land in order for it to be enforceable against successors in title. Such difficulties as have been encountered by the accommodate and serve test for easements reflect, to a large extent, the problems posed by the touch and concern test in covenants. The purpose of both tests is to ensure that capricious personal rights do not run with and bind the land and thereby constitute unnecessary incursions on the title. We don't currently feel that there's any need to abolish or to modify the requirement that in order to comprise an easement, the interest must accommodate and serve the dominant tenement. We come to a similar conclusion in relation to touch and concern. It seems to us the current requirements serve an important and legitimate purpose. They're reasonably well understood, don't appear to be intractable problems, and then reference to the fact that the Landlord and Tenant Covenants Act has relaxed the requirement for touch and concern in leasehold contexts. We consider there are qualitative differences between an obligation contained in a lease, which by definition is of limited duration, and an interest such as an easement, which may be attached to a freehold estate in land, the duration of which is unlimited. Now, there's a point of interest also in paragraph 3.31, 3.30, sorry, because the Commission discusses Edinburgh Park in terms which I recognise and I suggest fit quite tidily with my approach. If your ladyship sees the last sentence, the Court of Appeal in Edinburgh Park considered that the pleasure ground is in effect a communal garden. Then in paragraph 3.3, Milady, can I just invite you notionally to draw a sort of pencil line after paragraph 3.30, because 3.31 isn't a continuation of the discussion of recreation and amusement. It's going back to the Ellenborough Park criteria which were listed in paragraph 3.1, and it's saying the Ellenborough Park criteria are firmly entrenched, their rationale is clear, and we need just to note a point of interest. The first point, they say to avoid capricious and personal benefits becoming easements. Secondly, to promote clarity by demanding sufficient specificity at the time of creation. And thirdly, to ensure some degree of connection with the land in the same way as the touch and concern requirement does in covenants. Whilst there may be scope for some modernisation and tidying up, the core justifications for retaining these basic requirements are still present. So the Law Commission has looked at this and reached the view that there isn't a policy justification for changing what I would say is a strict approach to the need for accommodation. Can I then go back to paragraph 3.25 to make a point that I need to flag up, because I think there's a mistake in the respondent's case which I need to identify. Do you remember that in paragraph 3.25, the Law Commission said the purpose of both tests is to ensure that capricious personal rights don't run with the land? Now, a quick reading of that might be taken to suggest that there are three categories: property rights which do burden the land, capricious personal rights which don't, and non-capricious rights which do.
Where does this word capricious come from?
It's
Is it pure vituperation?
it's quite hard to trace, but it comes from, so far as I'm aware, it comes from Keppel and Bailey, which is mentioned in I think it is Hill and Tupper, but the extract I don't think is quoted in Hill and Tupper. But the point being made in Keppel and Bailey actually was a slightly different one. It was that, well, I'm not sure it's a different one. The point being made there was that the law should be hostile to the creation of novel rights. And in association with that proposition, as I recall it, the word capricious was used. So
Arbitrary might be better.
Yes. But the point being made is that the Law Commission isn't suggesting those three categories exist, and you get that. You can see from the bit I showed you over the page, 3.31. Actually, what they mean is capricious and personal benefits. A benefit is excluded if it is personal and if it's capricious, meaning either will do. Yes, Mr. Watkin has shown me that in Hill and Tupper you do actually find a quotation from Keppel and Bailey which uses the word caprice. And my lady, it's at memory stick page 1366. It's about 10 lines from the bottom. This is volume 3, tab 38. Where Lord Brougham said, it mustn't therefore be supposed that incidents of a novel kind can be devised and attached to property at the fancy or caprice of any owner. And I think that's the best we've been able to do in tracing the origin of it.
It is pejorative and not helpful.
No. So the point of the substantive point made by the Law Commission, which is, respect, entirely orthodox, is that the purpose of this test is to filter out personal benefits from real benefits, as Mr. Justice Warren had identified. If one then looks at the respondent's case in memory stick page 308, can I just call your attention to paragraph 169, where they refer to Mr. Justice Warren's speech in Polo Woods and paragraph 3.25, of the Law Commission's paper, and they say that the underlying purpose of the legal requirement is to ensure that capricious personal rights don't run with and bind the land and thereby constitute unnecessary incursions on the title. If that is meant to mean that the test should be wide enough to admit personal rights that are not capricious, it would be wrong. I would assume that it isn't meant to mean that, but I have a doubt because of what I read in paragraph 175 on memory stick, page 310, where they, having referred to the rights that I showed you them describing in opening on the facts, they say on no reasonable view are the rights under consideration here capricious personal rights. Well, maybe so, but I'm not interested in whether or not they're capricious. And that, I think, brings me to the respondent's test, which is in the preceding paragraph on this part of their case. Your ladyship remembers that they have based themselves on the idea of what is a normal use of property. And so in 174, they say, applying this to the present facts, the starting point is how purpose-built timeshare villas located on a small island of land within an extensive estate comprising a wide range of recreation and sporting facilities available to be enjoyed by the occupiers of other timeshare units on the estate itself would normally be enjoyed. The obvious answer, without the advertising and promotion materials, is for rest and recreation, and so on. Although referring to land in that formulation, the whole focus is on enjoyment. And we respectfully say that there are two problems here. The focus is wrong. As I showed you from the Polo case, the whole focus of the inquiry is to identify a respect in which it can meaningfully be said that the right in question is of benefit to the land. Now, that, of course, includes the use of the land. I fully accept that. But the whole focus of the inquiry must be on the extent to which the use of the dominant tenement is enhanced. There's a second problem which is hinted at here, but I suspect is not really intended. I mean, I hope there's not a suggestion here that by enjoyment in this context, one's looking at the derivation of pleasure. No, I presume that isn't the point that's being taken. A further problem with the respondent's test is that it involves the idea of a normal use, which, as Mr. Justice Warren pointed out, is problematic. And taking the respondent's formulation, my lady, it would seem to exclude, for example, a factory owner from taking an easement over a nearby swimming pool for the benefit of its workers. Well, if you can have an easement of a swimming pool, why shouldn't the factory owner be able to take an easement merely because swimming pools aren't normally associated with factory uses? It seems to be an unprincipled, it seems to lead to unprincipled and arbitrary outcomes. Milady, the same point actually shows that the requirement is circular, and this is the point I was discussing with my Lord Sumption, because the normal use of property may often depend on what rights are associated with it. I gave the example of a field. You can't really meaningfully describe the normal use of a field until you know what rights are associated with it. And one wouldn't deny the owner of a field an easement of water, gas and so on, merely because at the moment there was no house on it. Further, we say the respondent's approach doesn't explain hill and tupper or close farming, both of which it accepts are correct, and neither does it explain the free use examples. So we say that the normal use expression is just a shorthand which refers to the correct legal test but doesn't in itself state the test. My lady, we respectfully maintain the submission of the case. There is no coherent line that can be drawn apart from the one we have suggested. if and to the extent that the Master of the Rolls in Ellenborough Park correctly applied principle to the facts before him, it is because of the special features which he identified, which justified treating the garden as appurtenant to the house. There being no equivalent or anything like it in a case like this, there can be no basis for applying that reasoning to the facts of this case. Similarly, that brings me to ground 2. This is the question whether the rights granted require more than passivity on the part of the servient owner. And I think it might be helpful if I go back to the words of the transfer. Can I flag up, there are 4 other questions I'm going to ask your ladyship to have in mind while reading the text again, because I think they arise on the respondent's cross appeals. So when looking at the words again, may I suggest it will be helpful to have these additional questions in mind. The first is, did the grant envisage the use of recreational facilities which might be provided in the future apart from those present at the date of grant? The second is, did the grant envisage the use of recreational facilities which might in future be provided anywhere on any part of the surrounding estate, or only on those parts where such facilities were present at the date of grant? But thirdly, did the grant envisage that the servient owner might change the facilities offered in particular parts of the estate, with the dominant owner's rights of user applying equally to those new facilities? And fourthly, did the grant include a right to use the common parts of the ground floor and basement in the mansion house generally, or only for the recreational and sporting facilities provided in those parts? Can we then go back to the words in question, which I'm taking from page 479 of the core volume. And it's probably worth just taking 30 seconds to reread page 479. The first point I make, if I may, is that it's clear, and I'm going to show you, not really an issue, that the right contemplated was a full right to use facilities provided by someone else. One can't, in the context of this transaction, speak meaningfully of a right to use the swimming pool or the other facilities there, which doesn't entail that somebody else is going to be providing them as facilities and operating them for free for the use of the dominant owners.
It doesn't assume that they've got a legal obligation to do so.
Well, my Lord, I suggest that it does. I suggest certainly if you had stood back and asked the contracting parties at the date of the conveyance whether the right being granted was enforceable only through the indirect method that the operator of the facilities had an independent commercial motive to keep them going, they would have reacted in horror at that.
They'd probably have said, well, I've just spoken to my solicitor and he says that if this is going to be a valid easement, you can't impose that kind of burden as a matter of legal obligation.
Well, just the same solicitor will then have had to explain why it was that it was thought useful to include a personal covenant to maintain the facilities, which was going to collapse no less fully than the easements on a change in the dominant ownership. One can't, I respectfully suggest, proceed on the basis of that assumption. The correct approach, I suggest, is to examine the words that were used first, in the orthodox way, and then test them for the legal consequences. And to any reasonable person looking at this language and contemplating taking on this set of villas as dominant owner, the plain purport of these words is that there would be acquired a fulsome right of actual utility to use something provided by someone else's active operational intervention. And I say again, it would have been regarded as astonishing to hear any contrary suggestion. That's my respectful submission. So far as concerns the right to use any facilities that might be constructed after the date of the conveyance, I just flag up, I showed you that passage of Lord Scott's speech in Moncrief, memory stick page 902, paragraph 57 on this point about what is the dominant tenement in these cases. It's not the adjoining estate, it's the particular facilities on the adjoining estate which are affected by the rights. And of course, the effect of the respondents' interpretation, to the extent they say that their rights extend over the whole of the transferor's adjoining estate, is to create a class of inchoate right which will bind land on which there is at present no recreational facility, no matter into whose hands it might come. So completely empty open land might be sold off to somebody who puts up a new, for example, I don't know, a hotel on it, and in the hotel there's a billiards room. On the respondent's approach, they have a right to go into the hotel and use the billiards room. It's not a sustainable interpretation of the grant, in my respectful submission. As to the question of what rights are associated with use of the ground floor and basement of Manor House, we respectfully say, when you look at the words any other sporting or recreational facilities, they give you the clue. The rights granted relate only to sporting and recreational facilities. I next invite the court, I suppose this is a further answer to my Lord Assumption's point, that the very word used to define all these rights is facilities. And I think we can see a correct appreciation of the significance of that word in the respondent's case again. I think at paragraph 102, which is at page 277. Actually, I'd better come back to that point because I need to lay the framework by reference to the Court of Appeal's judgment. Let me come back to that. Anyway, I've made the submission that it's clear that this grant is one to use the facilities provided by others, which is fortified by the positive covenant. Now, can I then return to my submissions on ground 2 and the need for more than passivity on the part of the servant owner? First of all, it's common ground that a right can't be an easement if it needs more than passivity. In the respondent's case, there's no need to read it. The reference is paragraph 42. It's memory stick 254 to 255. The respondents refer to an exception. There is an exception for fencing, but they don't rely on it. What the respondents say, my lady, is that they could use all these facilities themselves if the servient owner didn't provide them. This is their case at paragraphs 186 to 190. But I respectfully say that's not the point. The question is not, could the respondents club together to provide the facilities if they wanted to? The question is, what rights were actually contemplated by the grant in question as a matter of interpretation? Now, in this regard, we, of course, cited Street and Mountford, Elitestone and Morris, as indicating the correct legal principle. You construe first, then you identify and apply the legal consequences. That's our case, paragraph 96. We also pointed out that this was the approach taken in Moody and Clapman. We make that point in paragraph 97. And we pointed out that the cases mentioned in the Court of Appeal below did not justify any different approach. These are Rance and Elvin and Duffy and Lamb. And see our case, paragraph 90. Now, my lady, there's been no answer to any of those submissions. The respondents don't refer to Street and Mountford, or Elitestone, or to Rance, or to Duffy. I think Duffy is mentioned on a different point at paragraph 127 in that case, but it's not relevant to what I'm now saying. Indeed, I have to say, my lady, that the respondents don't even recognise that the point at issue under ground 2 is a point of interpretation at all. What they're relying on is a general principle which states that where what was granted is an easement, it carries ancillary rights. But that assumes the thing which needs to be proved. Before you can rely on ancillary rights, you must first show that the rights you acquired were easements. Otherwise, there are no relevant rights to which anything can be ancillary. So a necessary precursor to relying on ancillary rights is to show that the right to which their ancillary was an easement in the first place, which is the question of construction first, and then considering the legal consequences. So, lady, it's not enough for the respondents, as they have done, paragraphs particularly 186 to 90, it's not enough for them to show that the rights granted, if effective as easements, carried ancillary rights. They need to start by showing as a matter of interpretation that the rights granted in 1981 required nothing more than mere passivity on the part of the servient owner. And I don't detect any submission in their case which even does so. It makes the attempt. And in fact, when one analyses the cases, there's a surprising amount of common ground about the factors which are relevant to interpretation on this point. I've shown your ladyship the list of facilities which is agreed at paragraph 14 in page 173 on the memory stick. The Court of Appeal accepted as a matter of interpretation that some items on this list involved more than mere passivity from the servient owner. Perhaps I can ask you to read again paragraph 80 of the Court of Appeal's judgment. The Court of Appeal's judgment appears more than once in the volume, unfortunately, but I'm using the version at memory stick page 381. Paragraph 80, where the Court of Appeal is considering the reception, billiard room and TV room on the ground floor, and says it's important to note that the easement granted is, on its proper construction, as we've already said, to use any sporting or recreational facilities that exist on the ground floor of the mansion house at the date of the 81 transfer. On no analysis can the reception area or its inevitable back office comprise such a sporting or recreational facility. Moreover, what we have said about the modern approach to taking physical exercise is not really applicable to recreational game. Mr. Randall urged us to accept that the easement is really no more than a right to use the common parts and facilities on any part of the ground floor of the mansion house. We think this submission proves too much. It shows that the right granted is really not in the nature of an easement at all. It's not about the use of any land, but the use of facilities or services that may for the time being exist on the land. As with the case of the restaurant, which was in the basement in 1981, we cannot see how there can properly be an easement over such a service area. A restaurant's not like a toilet. It can only be useful and of benefit if someone cooks the food and sells it to the user. Likewise, a TV room is of no benefit without a TV. Now, my lady, can I then show you what we said about that in our case at paragraph 98, going back to page 218. paragraph 98, we said the Court of Appeal recognised that the need for active intervention by the servient owner disqualified rights from being easements when considering the restaurant and the other facilities within the mansion house. And I then quoted that part of the judgment which I've now shown you. In paragraph 99, we said that reasoning is correct. However, the court failed to apply the same logic to the other facilities. In truth, the rights granted in the present case amount to the right to enjoy facilities provided through the performance of functions by the grantor on the grantor's land, conditional upon the grantee's ownership of identified property nearby. And we return to this point in responding to something that the respondents have said in their grounds. Paragraph 131.2, which is at memory stick page 231. In their grounds, they were arguing that there is, in principle, no difference between the recreational facilities described by the court in its judgment as being present in the ground and basement floors of the mansion house and other recreational facilities that were outdoors. And we made the point. That's very true, but it proves too much for the respondents because it illustrates the correctness of our argument on our own appeal. So we adopted what the Court of Appeal said in relation to that limited class of rights in relation to all the rights, and we find that the respondents said the same thing in their grounds, and they say the same thing in their case. This is now page 277. Paragraph 102. Even if the construction adopted by the Court of Appeal were to be corrected, there is in principle no difference between the recreational facilities described by the Court in its judgment as being present in the ground and basement floors of the mansion house, in respect of which the Court found there could be no valid easement, and other recreational facilities that were outdoors, in respect of which the Court found that valid easements did exist. And they go on to say that it should follow that the easements inside should be regarded as valid. So it turns out, lady, to be common ground that all of the rights granted in 1981 required more than mere passivity on the part of the owner as a matter of interpretation. We also say that it is of the essence of the rights granted that they require more than mere passivity. This is, for example, paragraph 94 of our case, page 217. Now, the nearest one gets to understanding the respondent's position on that is from the paragraph I've shown you twice now in their case, paragraph 174 at page 309. Where the factors which they rely on in order to suggest that there is that necessary that connection which must be established between the two parcels of land to count as an easement, what they're relying on is precisely the point that it was of the essence of the scheme that these facilities should be provided by a third party. And I showed you the quotations from the marketing material that they rely on to support that point. So it seems also to be common ground that the provision of these facilities by the owner of the servient land is of their essence. Not like, for example, Ellenborough Park, where, as my lady pointed out, there was a covenant of maintenance on the part of the servient owner, in that case too. But the Master of the Rolls evidently didn't regard that as being of the essence of the right granted in Ellenborough Park. But here, the whole right is to have someone else provide the things which, it's common ground, are services and facilities. Now, a right to use facilities for free necessarily entails that someone else will provide them. which must involve more than mere passivity on the part of that other person. We suggest that the Court of Appeal has treated the rights to use the facilities as surviving a change in servient owner, but only in a stripped-down form. After a change in the owner of the facilities, says the Court of Appeal, they turn into something completely different. They're just a hollowed-out shell of what was actually granted. And all of a sudden, the villa owners have nothing more than a right to go on and put water in a swimming pool if it's empty, maintain and run their own golf course, and so on. That is a completely different set of rights from what was initially created and what was clearly intended. I suggest that no reasonable person in the position of the parties would think that these rights could be of any utility to an occupier without the covenants which supported them. And to interpret the rights in that way would mean that they changed depending on who the owner happened to be. While the original owner was still around, they had this intended fulsome quality, but thereafter they shrunk unaccountably. Respectfully suggest that this is not a supportable approach to interpretation. One looks at the grant and finds fulsome rights, full rights which were granted, involving more than mere passivity on the part of the servient owner. And, my lady, I suggest you test those for whether they are property rights. And this isn't a point the respondents have addressed at all. And I say the personal covenant does have a bearing on this. It's wholly artificial and unrealistic to treat that covenant as if it were separate from or independent of the rights to use the facilities, because the two are corollaries. They were clearly intended to go hand in hand to create a complete package of enforceable rights on the part of ultimately of the occupiers of the villas.
And it cuts both ways, doesn't it? One reason for including personal right would be a recognition that there wasn't a burden being imposed by the real right.
Well, my lord, that point is available in, for example, the Ellenborough Park case, where it could be said that the obligation to maintain wasn't of the essence of the rights that was granted. But here, I suggest, if you're standing back and being objective and dispassionate about what the language used would mean to reasonable people in the position of the parties, in this case, one would recognise that the provision of the facilities by the servient owner was absolutely of the essence. And in such a situation, one can't separate out usefully, meaningfully, in a way that respects ordinary principles of interpretation, I respectfully suggest, the positive covenant from the rights granted. In this situation, the two are intertwined, even if in other cases, like Ellenborough Park, the court might be able to adopt an interpretation which regards them as independent.
Rather striking reversal of the normal process of construction by which you interpret covenants so as to, as far as possible, you are interpreting this covenant so as to make it as right as possible to avoid.
I suggest I'm adopting a neutral approach, an even-handed approach. The approach which your lordship describes is the approach taken by the respondents. They say you have to approach the rights themselves in an expansive way in order to respect the clear intention, the subjective intention, to create property rights. I respectfully suggest I'm being entirely neutral about this point and treating one part of the conveyance like the other. When you look at the conveyance as a whole, including not only the rights granted, but also the positive covenant, what you recognise is intertwined and correlative rights and obligations. You can imagine an even simpler case than Ellenborough Park. If I take a right of way over my neighbour's land, as well as a covenant by him to build the roadway, nobody would suggest in that situation that I could only exercise my right of way if he complied with his covenant, But that is because there is a sufficient degree of independence between the right and the obligation to build. In the case of our facilities, they are things that can only be provided by active, continuous intervention on the part of the servient owner. In that completely different context, I respectfully suggest it would be quite wrong to regard as separable the one from the other, the rights which were granted and the obligations imposed, as it turns out, personally on the servient owner. Also, Milady, I would say there's no suggestion that there can be no suggestion that the grant is unclear or ambiguous. It's quite clear that this grant conferred fulsome rights to use these facilities. And, Milady, what's happened is that the law of property happens to prevent them from surviving a change in the ownership of land. But the grant didn't contemplate that the price of perpetuity would be a loss of utility. It proceeds on the basis that the same rights which were effective contractually on day one would be equally effective in perpetuity even after a change in ownership of the servient land. Now, in that, it embodies a mistaken view of law, but that's no reason to depart from its clear meaning. And that brings me to make a submission about what, in substance, when you look at it, the respondents are asking the court to do. They're not actually asking you to vindicate the rights which were granted to them by the contract. What they're doing instead is asking you to salvage something from the 1981 conveyance, even though, in order for it to be perpetual, the rights that can survive are just hollowed out husks of what was objectively intended. And we see this actually in their case in paragraphs 189 to 190. I don't know if you'd like to turn it up, but this is memory stick page 315. They candidly make, I think this is Lord Sumption's point, that the appellants are free to maintain the facilities if they so choose. The appellants rely on expert report as to the amount they've in fact spent. This is of little assistance, as it's obvious that there is cost involved in maintaining a golf course. Furthermore, whether or not the golf course, or for that matter the whole country club-style leisure resort, is profitable for the respondents depends on what they generate from various other sources of income, at what level they set their prices to paying customers, to what standards they choose to maintain the course, and so forth. It should be noted the trial judge found, as a matter of fact, that the appellant had other commercial motives for maintaining the facilities, and they're listed. So what they're asking you to do is not to vindicate a contractual right to have these facilities provided. They're asking you to enable them to continue the stalemate situation, the commercial stalemate situation in which, if my client is to make profitable use of the servient land, it can only be at the expense of allowing the respondents to make free use of whatever facilities he chooses to provide. What they're seeking to vindicate is a negotiating position. That's what it comes down to. And that is very remote from what was contemplated by the terms of this grant. It's just not what was promised. Yes. Milady, without taking up time on it, I just want to go through the points that I've made in my case at paragraphs 88 to 107, which deals with this ground too. I think I probably have.
And the only authorities which you rely on for this proposition are really the Ranson, Elvin and Duffy and Lamb, which are about obligation to apply water or electricity.
Those are the authorities relied on by the Court of Appeal to say that it didn't matter. Yes, but as we've said, the point couldn't really arise in those cases for reasons that we've suggested.
There's a case about a collapsed bridge,
Yes.
which is relied on by some.
Well, again, it doesn't really take matters any further, I respectfully suggest.
I mean, you're really relying on what the interpretation of the grant, which is to use facilities, and you say that implies something more than just going onto a bit of land and building yourself a golf course.
Yes. And it's no good saying that if we had an easement, we would have ancillary rights to do it. What's missing in this case is the step of reasoning from the respondents, which shows that what they were granted in the first place had the characteristics of a property right. In this underground 2, the bit that's missing is that they call on the servient owner to be more than passive. But I don't think I'll take up more time reading what I've printed, but I just remind the court of what I said in paragraph 100 on page 219. In truth, the rights granted in the present case amount to the right to enjoy facilities provided through the performance of functions by the grantor on the grantor's land, conditional upon the grantee's ownership of identified property nearby. And, Lady, I suggest that this goes back to the point I was discussing with my Lord Sumption earlier about why it is that this kind of arrangement isn't sufficient to be recognised as a property right. All that's been granted is a right to use something if you own land nearby. That's not enough to qualify as an easement. Lady, I'm about to turn to ground 3 Ouster, but I notice the time, and I think I would prefer, if I may, to give up the 2 minutes before 1 o'clock, rather than launch into Ouster.
Well, if that's what you'd prefer, Mr. Morshead, who are we to
My voice
force you
is
to remain on your feet for any longer than you desire? As long as you can complete your submissions within the time allotted to you, that is fine.
Court will now adjourn.